It's 8 minutes to 8. We've been talking quite extensively about the ACT government's decision to compulsorily acquire the Calvary Public Hospital at Bruce. But what does that mean? What does compulsory acquisition mean? How does it work? Alex Martin is a business lawyer and litigation expert and a partner at Taurus Legal Management. He joins us on the line now. Alex, good morning.
Good morning, Stephen. It's good to be with you again.
Now, I know you can't talk in specific terms about this, but compulsory acquisition, normally when we hear these things, it's about, governments need to be building a road or a freeway and they buy the houses in the way of where this freeway is going to go. What are the legalities around this, though? Surely there's got to be issues of natural justice that come into these things.
Yes, so that's true. Normally you're looking at an acquisition of a power pole or of a bit of a rural land as a development site or something like that. This is a lot more complicated because you're dealing with land, obviously a significant bit of land. You're also dealing with buildings and equipment, which are very valuable, and there's going to be a dispute about what they're worth. And you're dealing with really the business of a hospital, so it's a bit of uncharted territory in terms of what the government normally do. Certainly there is natural justice issues that the hospital needs to be able to give to have its say onto what it thinks the land and the business is valued. But at the end of the day, the government does have the power to acquire land for public purpose, and this falls within that.
So when these things are invariably challenged from a legal perspective, can the actual acquisition itself be challenged, or is it generally the compensation involved that is the subject of any legal fight that might come afterwards?
Excellent question. There's a whole lot of legal issues in this. There's the Land Acquisition Act in the ACT, which allows the government to acquire land, and there's obviously constitutional issues, as we all know, from the capital, and whether you can acquire land on just terms and so on. But my view is that ultimately, if there was a legal challenge, it would be just in respect of the amount that the government need to pay. I think if there was a challenge around the legality of acquiring land at all, it would fail. And so that the land would be acquired. I think there's plenty of precedent around to show in the ACT and elsewhere that the government, if it passes legislation, has the power to acquire land without the consent of the owners.
Because that's what's happened here, is the government has actually passed separate legislation, or not passed it yet, but introduced into the Assembly separate legislation for this particular acquisition. Is that normally how it happens?
No, very rare. So normally it's under the ACT's Land Acquisition Act, which was passed in 1994, and that's normally sufficient for the kind of acquisitions they do. That's the acquiring a bit of a paddock somewhere for a development site, which they've done in the past. Yeah. But this is a bit more complicated because it involves really a complicated business like a hospital, and so they've introduced special legislation just recently into the Parliament to try and deal with all of those issues. And that legislation is expected to pass, and I think, but it needs to be much more detailed than just what's set out in the Land Acquisition Act.
Yeah, because it's going to be put before the Assembly on the 31st of May and bypass all the committee processes that are normally in place. Given that that's the way it's going, are there constitutional issues around the way the legislation might be dealt with as well?
There could be, yeah. That bit of legislation could be unconstitutional. It could be challenged on constitutional grounds. But really, the Constitution doesn't say very much about compulsory land acquisition, except that it's allowed on just terms, which means conventionally means payment needs to be made for the land at market price. So as long as the legislation pays market price for the land and buildings, and obviously what market price is can be disputed, but as long as there's a payment of whatever market price is determined to be, then it's likely to be constitutional. So I don't think it'll be struck down for constitutional reasons.
Because I imagine that's the difficulty here, is how do you put there wouldn't be a standard market price on a hospital because they don't get sold every day.
Exactly. That's the real sticking point. I think not whether they can do it, but how much are they going to have to pay. I know they've made an offer to pay $77 million back in 2010, which was knocked back, and they've tried to negotiate a deal recently, another 25-year deal, when the current deal goes for 76 years, trying to renegotiate this deal. But what you pay for the buildings, what you pay for the land, and then what you pay for the business effectively is really a very tricky thing to work out.
So this could be a very, very ugly episode before it's all over.
Sure, it could end up in court for many years, but as I say, not about whether or not they can take it, but about how much they have to pay, and I think it's going to be very expensive for the government.
Yeah, absolutely. Alex, I really appreciate your time. Thanks for joining us this morning.
Pleasure, Stephen.